Namaste and welcome to Pods by PEI, a policy discussion series brought to you by Policy Entrepreneurs Inc. My name is Sonia Jimmy. In today's episode, we have PEI colleague Soumitra Neupani's conversation with Semanta Dahal to discuss political question doctrine in Nepal's judiciary. Semanta Dahal is an accomplished legal professional with a BA and LLB with honors from the National Law School of India University, Bangalore, and an LLM in International Law from the University of Nottingham. Currently, Semanta is an advocate and partner at Abhinava Law Chambers in Kathmandu, where he provides legal expertise across various aspects of Nepalese law, regulations, policies, and market practices. His advisory work encompasses areas such as hydro concession, infrastructure finance, electricity laws and regulations, land matters, cross-border investment, and potential power trade with India. Soumitra and Semanta discuss Nepal's political question doctrine in the judiciary, drawing from Semanta's article, Political Questions, Your Honor, published in the Kathmandu Post. The two explore how the Nepali judiciary applies this doctrine and handles intricate adjudication processes. We hope you enjoy the conversation.
Good morning, afternoon, and evening, wherever you're listening. Welcome back to yet another episode of Pods by PEI. Today I'm conversing with Semanta Dahal, a practicing lawyer, and the topic of our conversation is the political question doctrine in Nepal's judiciary. Welcome to the show, Semanta.
Thank you. I'm delighted, and thanks for inviting me to the show. I've been following the PI pods for a long time, and I found those episodes to be very intriguing, and it is also resourceful in many ways because it has supported the policy reforms drive that PI is trying to implement in Nepal, and I look forward to the conversation.
Great, we are honored. Semanta, I want to begin today's conversation on the premise of your article, Political Questions, Your Honor, published in the Kathmandu Post some time ago, where you discuss Nepal's Supreme Court having to often tackle constitutional disputes, which are both legal and political in nature. In this article, you are essentially discussing the practice around enforcement of the political question doctrine. For the benefit of our listeners, maybe briefly elaborate on this notion to begin with so that we make some grounds. Talk about how actually the political question doctrine got established and what it is.
Sure. Thanks for citing that article that I wrote a few months back for the Kathmandu Post. The aim of that article and other columns that I've been writing for the Kathmandu Post under the third branch is to examine primarily to see if law has started occupying the space of politics. That is the main aim of the article and also the column. With regard to this, whether, when, and how this political question doctrine got established or enshrined, we might have to go all the way back to 220 years ago. That's a long, long time ago. And it was tumultuous time in US. Politics was still fragile, fragmented. And it was right after the constitution that got promulgated in the US, like 20 years after the US constitution was passed. They were also a very young democracy back then, and the political parties were in their deepest, bitter rivalry. And the US Supreme Court came into this picture between the two political parties' dispute back then. So I can elaborate on the case a bit. It is the seminal case of Marbury versus Madison. And this is where, simultaneously two doctrines got established at the same time. One is the doctrine of judicial review, that is the power of the court to review the acts and the laws passed by the parliament, and also the power of the court to see whether issues can be delineated between political question and a legal question, and how can court then deal with the legal question primarily in delivering these decisions. To highlight what had happened in that case was, I can briefly give you the facts also because it's pretty interesting. There are two major political parties in the US back then. One was the Federalist on one side, and there was the Democrat Republicans, and those two parties were fighting the presidential elections. John Adams, who was the president, lost the elections, and he was representing the Federalist Party, and then Thomas Jefferson won the elections. He was from the Democratic Republican background. But there was a long period of delay between the election of Thomas Jefferson and his inauguration. So John Adams was still the president. And he wanted to fill certain federal vacancies, especially in the courts during that time. So he started filling the vacancies, and a number of positions in the federal courts were appointed, including a person called William Marbury for one of the positions. And he was confirmed by the Senate, but then he was not given the paperwork saying that he's been appointed. Now, in that transition, Thomas Jefferson came to power, and Thomas Jefferson asked his Secretary of State not to issue the paperwork, so William Marbury didn't get his appointment. Then he went to the court asking that he should be appointed to the position. The court then started evaluating all the fact situation and came to a conclusion. Primarily, it was Chief Justice John Marshall, who then didn't want to get into too much of dirty politics between the two parties, because he was worried that if Supreme Court issues certain decisions and Thomas Jefferson, who is the new president, doesn't abide to that, then it will be an embarrassment to the court. So he played very thin line there and adeptly established the doctrines, both judicial review and political question doctrine. Two statements and the decisions are very, very critical. One, he says that it is emphatically the province and the duty of the judiciary to say what the law is. That's one statement. And the other statement is questions which are political in nature, which should be decided by the executive under the Constitution, should not be presented to the court. Now, both these statements are mutually conflicting to some extent. But at the same time, I think court also wanted to play very safe between the two to say that, okay, political questions should not be brought to the court. This is how it got really established. And the doctrine got a little more, I would say, developed in 1960s during the case of Baker versus Carr. Baker and Carr, what it did was it primarily laid out 6 criteria to distinguish between what is a political question and what is a judicial question.
Can we say what those 6 criteria were?
Let me just give you a background of the Baker versus Carr issue also. The case again was around 1960s, if I'm not wrong. Charles Baker was the mayor of a town in Tennessee, state of Tennessee. And the state of Tennessee, there was the redistricting of districts happening based on the population. Now, what Baker contested was, during the redistricting, it was not done in a very reasonable manner, and the population was not reasonably accounted to give equal districts in the way it was required to be done. So then he went to the court saying that this is wrong. And the Supreme Court then came to a conclusion that malappropriation is a justiciable violation of the Constitution, and that Supreme Court could intervene in that and redirect the district to be done once again. So in doing that, it kind of elaborated 6 criteria to see what could be a legal question or it could be a judicial question. First, it said whether the executive or the legislature had the express authority to resolve the issue. Second, if the issue could be judicially managed by the judiciary or not, whether the judiciary had the power to discover the issue in question. Third, because policy making comes into the domain of the executive, whether judiciary can really use its discretion to make some certain policy determination for the executive or not. The fourth one was by intervening, whether that will amount to disrespect by the judiciary of the executive. Fifth was whether or not the political decisions can be questioned, or whether or not the court would have to adhere to the political questions already taken without asking any question. And last was there could be interpretation of the same issue by multiple branches of the state, and if it is interpreted in a different way, then whether that will be an embarrassment to the judiciary or not. So based on this kind of 6 criteria that U.S. Supreme Court kind of established for the first time, in a detailed way of examining whether a question is political or judicial or not.
So going by the genesis, as you've pointed out, this looks like a function enforcing the principles of separation of power in the state.
Mm-hmm.
A lay understanding would be that this is, some sense, a boundary line between the judiciary and the executive, but something that the judiciary enforces, right?
Yeah.
It's not the executive saying that this is the boundary line, but it's in some sense, judiciary's own formulation as to whether they are to take certain cases or not.
Absolutely. The traditional explanation of doctrine of political question is preservation of separation of power. It is to delineate, what falls under the issues to be decided by the court and what really falls under the domain of law and what is more constitutional that the court could decide on. So it is mainly intended, as you said, to respect the separation of power. And that is what the view the Nepali Supreme Court also has taken. And I can cite one case here. This was the first case of House dissolution that happened in late 2040s, around 51, I think, when erstwhile Prime Minister Girija Prasad Koirala decided to dissolve the parliament and call elections, although the Congress party back then was the majority in the parliament. The Supreme Court then examined the issue because it was presented to the court. Supreme Court then saw what was the reasons behind Girija Prasad Koirala taking the decision to dissolve the parliament, and what are the political reasons that the prime minister had cited for that. Then Supreme Court said, I will not intervene or look into what are the political reasons that the prime minister cited for dissolving the parliament. That's not my role, because I can't go behind and evaluate the rationale and the reasons behind the political reasons that the prime minister has cited, because that will be going against the separation of power. So it is a doctrine in many ways established by the court for its own benefit, so that it doesn't intervene or does not usurp some of the powers of the other branches of the state.
Excellent. Just as we are on the topic, you mentioned the Supreme Court case from the US where they had laid out 6 principles. So as this is being practiced in Nepal, do we have certain principles, similar principles laid out, or it is very prerogative of the Supreme Court practice in Nepal that they decide what cases to take or not take, given their own understanding, or there are principles within the judiciary system that are established to kind of make those inferences?
The principles are laid out, definitely. The principles are similar to what Baker and Carr has laid out. One point that Supreme Court has really emphasized in Nepal's case was whether the issue in hand or the issue to be decided by the court can be discovered by the judiciary or not. In layman terms, whether it is judicially manageable standards or not. That is something the Supreme Court of Nepal has expanded on a number of times. But then that question, when it gets discussed in the court, could have arguments from both sides. And I can currently give an example of the latest controversy that happened in Koshi province, where the speaker, whether he was entitled to vote for the formation of the government or not, or whether he was entitled to side with one of the parties or side with one of the in a coalition for the formation of the government or not. And that came to the Supreme Court. It was raised that there is an issue that Supreme Court can't manage because it is not judicially manageable standard. It doesn't fall under that framework. In that case, the Supreme Court did say that it is the role of the judiciary to see if the constitution has been violated or not. And Supreme Court came to the conclusion that speaker, who's supposed to be the umpire of the parliament, of the house, siding with one side goes against the constitution principle. But if you look into the constitution, there are no explicit provisions saying that for a formation of government, the Supreme Court, the speaker can't take sides. It is only for other motions presented to the parliament where there is an explicit bar on the speaker not to vote, not with regard to formation of the government. But then Supreme Court drawed the inference that if in other motions the speaker can't vote, has to remain neutral until there is a tie of votes, then even in the case of formation of government, the speaker should not be taking any stand. So that is where I think if you examine the issue, speaker participating in a democratic process of voting could be said that it is not an issue that the judiciary can really manage. But at the same time, it can be argued that judiciary can manage because there is some violation of the constitution at the same time. So it is very difficult to make a case in any issue whether in which side the Supreme Court will take a stance on, because I know sometimes what really happens, and I'll borrow this quote from De Tocqueville, who gave this quote. He said, "There's scarcely any political question arises in the United States that is not resolved sooner or later into a judicial question." A political question gets converted into a judicial question somehow or the other.
I'm trying to put myself in a position of a judiciary who has got a question in front and needs to abdicate. So in the Nepali system, does it work in the sense that there are norms defined within the language of law where the judiciary, when a question comes, they go and look at some tick boxes maybe, okay, if this is right, then maybe this is a political question or this is a legal question? Or is it based out of previous principles and practice of law that the Nepali judiciary has acted upon? Or it is a matter of one judiciary trying to understand what the case is and then trying to adjudicate whether that is a legal or a political question? Or it is all of those above?
Yeah, that's a very important question and very valid question, Samitra. In terms of the law saying, okay, this is how you can distinguish between a political and legal question, there is nothing written in the law. And law in the sense I'm talking about legislations. But the judiciary is also allowed to make laws because through the decisions, So when judiciary tried to make laws, they have established certain criteria and they borrowed the principles of Baker and Carr in Nepal's case too. And as I said, those tick boxes are there. But which judge will say, okay, the tick box is right or wrong, depends upon that particular factual scenario and the case and the arguments presented. And sometimes there could be extraneous political factors that could come into play. at the same time.
Excellent. Just before we move forward, Semanta, there's something that I wanted to clarify. As we are on the topic of separation power, there's this norm around separation of power and judicial activism. So how far off is this idea of judicial activism from the political question doctrine?
Within the political question doctrine, there could be both judicial activism and judicial restraint will have some space to play. And it'll be wrong to assume sometime that, judicial activism and judicial restraint are mutually exclusive. One has to choose between the two. And my take is that depending upon any factual scenario and the issue or the dispute to be resolved by the court, I would lean into one of those. I could lean into judicial activism in certain case. I would lean into judicial restraint in certain case. For example, if I were, as you said, you are assuming to be a court judge. Like if I were in the same place, then I would say, okay, if the court assuming the responsibility to adjudicate the issue will interfere the democratic process, then I would not try to interfere, because it is primarily the role and the responsibility of the political institutions and leaders having political role to implement the constitution, especially a young constitution which is still to be developed. And in that case, if it is really an interference of a democratic or a political process, then I would not try to intervene and restrain from assuming jurisdiction. However, if it is at the same time the issue could really help in making sure the constitution continues as a living document, and you could infuse life into the constitution, because constitution when it's passed is meant to last for centuries. It's not designed to last 20, 30 years. So if it is a case to make sure that the constitution stands as a living document, and we try to harmonize the constitution to meet and adapt or modify to the social developments and aspiration of the people, then perhaps there is a need for the judiciary to be more active. And the case I'm trying to make here is because compared to other political institutions, judiciary can be a little bit progressive. And the main reason why judiciary can be progressive is in other institutions, executive and the legislature, arriving at a consensus is a very excruciating process. But within the judiciary, if the bench is 2 or 3 people, they can arrive easily at a consensus. So because arriving at a consensus is easy at the judiciary compared to other institutions, the judiciary can be a little bit more progressive. So that's the reason if you want to implement the constitution as a living document, then in that case maybe judicial activism is required. And that's been the case. Our human rights jurisprudence got expanded because of the activism. Our environmental jurisprudence, protection of environment got expanded because of judicial activism. Even voting pattern or even the right to vote of absentee people who are residing outside of Nepal. That's the case of Supreme Court taking an activist stand, in many ways. But that is also required because at the parliament or executive coming to a conclusion that, okay, we want to allow voters outside Nepal to vote, that will be a long drawn process where they might not come to a consensus. But the judiciary could really arrive at a quick consensus there. So because of that, judiciary could be progressive, and for judiciary to be progressive, judicial activism may be required. So depending on the issue, we could lie on both the sides of activism and restraint.
This is also a highly contested topic in the sense you could easily be stepping into the executive functions if you're more into that activism mode, right? There have been examples globally where judicial activism is often criticized by opponents, especially from the executive, for overstepping boundaries.
Exactly, that's absolutely true. And Nepal's judiciary has also suffered that and has received its fair share of criticism in certain cases, definitely.
Before we move the discussion further, Semanta, it will help me as well as the listeners to unpack this question of political doctrine through questions. And I'm putting you in a spot, and a challenge for you is, why don't we go out and list down 3 cases, discuss briefly 3 cases. Case 1 would be a topic where the judiciary, in the sense, used the political question doctrine to not intervene because they thought a matter was political. The second case could be something where the judiciary acted on, saying that this was, in fact, a legal case. And a third case which you think lies in the gray. For the third case, we won't say how the judiciary acted, but we'll just throw it out for the listeners to decide for themselves what that case was.
Let's start with the third case, where it's a gray area.
Okay.
We go back to 2020 when the Constitutional Council appointed certain positions, certain people to different constitutional bodies, including the Commission for Investigation of Abuse of Authority and also to the Election Commission. Before that appointment, there was a very long-term process that was going on where the opposition parties were invited to the meeting because Constitutional Council also has a representation from the leader of the opposition party, but they could never have at a decision to really appoint the people. Then Oli's government back then brought about an ordinance, changing the composition, not even changing the composition, changing how we could call meetings. So the ordinance basically said, okay, the first meeting, this is the quorum required, and people don't turn up, then the second meeting is called. It was done through an ordinance. So the first meeting was called, not everybody turned up, including the Speaker of the House, Agni Saab back then. Then the Prime Minister called another meeting where through the ordinance he had already amended the law. So he could then appoint based on the quorum that he had, and all these appointments are made. The question now is that issue has been challenged to the court. Now, whether court should say this is a political issue or a legal issue. Because, if there could be arguments from both sides, it could be considered a legal issue to argue that because Constitutional Council's spirit and the requirement is that there should always be a representation from the leader of the opposition, and avoiding that is a breach of constitution, then that becomes a very legal issue, and the court could definitely say, okay, I'll intervene and say that what was done is wrong. But I'm just evaluating the scenario here because I can't comment too much on the court case which is sub judice. Second is, court could also take a stance saying that the Prime Minister has the authority to issue ordinance when the House is not in session, and that is allowed under the law. And what the Prime Minister has done is a political process, because appointments to all these bodies are a political process.
Done through the executive.
Done to the executive. So the court will say I might not want to intervene. So there could be both scenario there in a typical, this kind of a case where there's a gray area to argue.
Okay, this is the third case, and it's for the listeners to decide if this is a political or a legal question.
Yeah, exactly. It's for the listeners to, or in fact, it's in the court of the Supreme Court in many ways. So at some point in time, the decision might come. But let's wait until then, and the listeners can really examine from their side.
Namaste. Hope you've been enjoying our episodes. Pause by PEI will be taking a season break from October 15th to the November 15th. If you haven't had the opportunity to catch up on our previous episodes, this may be a good time. Thank you for listening and supporting us throughout the season. We will be back with new episodes and fresh content after the break. Until then, take it easy.
Let's now see the second example where you said, okay, this is a legal question. It's not a political question. There's a case again to really cite a previous Supreme Court judgment. This is about, I think, again, 1995 or 96 when the Supreme Court issued the verdict. There was a gentleman called Kalyan Bikram Karki. He was already an ambassador to France. But then government or the king had the power to appoint the ambassadors after taking advice and consent of the Council of Ministers. So Kalyan Bikram Karki was then also appointed or given ambassador post for other two countries, Spain and Israel, including France. But on the record, there was no paperwork or correspondence saying a Council of Minister had given his advice and consent. Although the appointing power was still with the king. But the Supreme Court said that there is a political relationship between the Crown and the Council of Ministers, and that political relationship has to be adhered to, and that it said that if there is no advice and consent from the Council of Ministers to the Crown, then Crown appointing the person is against the Constitution. So that is something that courts really intervened, saying that although it was a political process on how the appointments were made, but the political process lacked due
processes.
Yeah, and that's the reason the court intervened. So that is an example of where court had really intervened, one case. The other one was, again,
where they didn't take up a case.
They didn't take up a case. I'll cite, if I remember this case facts very well. It was in the provision of the interim constitution, which it said that there will be a commission that will be constituted by the executive to restructure the state in terms of federalism and other recommendation. This was still before we passed the constitution. 2010-11 is when the case came. And one of the petitioners, Dr. Chandrakanta Gewali, went to the Supreme Court saying that a writ of mandamus has to be issued to the executive to fulfill that responsibility of establishing this commission for restructuring the state. The Supreme Court came to a conclusion that that is not for me to decide and recommend to the constitution, the executive. If it is written in the constitution, the executive can do it. It is a very political question whether executive when it wants to constitute the commission. So I will not intervene. So there are all three examples of cases here. But more or less, to sum up, more often than not, you will find that a political question getting converted into a judicial question, and Supreme Court taking certain stance on this issue.
You talk about this in your own article in the Kathmandu Post as well. These were brilliant examples, and something that really stands out for me on the topic is this question of judicial independence, especially if you've been somebody who's observing how the politics has unfolded in Nepal in the recent past. You see judiciary in the question being questioned time and again, and the reputation of the Supreme Court kind of being tarnished with this particular norm of judicial independence. When you, in some sense, people call them political expediencies of the judiciary in national sensitive matters, even often criticized by Nepal's own judicial fraternity for certain decisions. How do you see this question of judicial independence in Nepal, especially in the context of what has happened in the recent past? I'm especially interested to hear if there are 2-3 key issues or factors within institutional provisions that kind of really expand these questions of judicial independence in Nepal.
Okay, very good question, and something that I've been thinking and trying to see more clearly and have my thoughts cleared more deeply on those issues, but I'm still hazy on some of my thoughts on this. But let me start. What I can definitely, and something we should be also considerate about, this is the longest period in history where Nepal had a democratic stability. It's a rare exception for Nepal. From 2006 to 2023 now, it's been the longest that Nepal ever had or enjoyed, and very rare that a stable democratic period. Although a stable democratic period, in many ways you can question that the political parties, we never had a strong government in place. The prime minister kept on changing, but that is more on the prime minister and the government not being stable. In terms of political stability, there's still democratic stability. I won't say political stability. Let's call it a democratic stability, and that's been a rare occasion there. However, that is on the executive side. If you compare to the judiciary side, judiciary has gone through the most tumultuous phase in Nepal.
Can you elaborate on that?
It never happened. Before that, sitting Chief Justice was trying to be impeached twice. But sitting Chief Justice was made to resign or had to resign because of his own shortcomings, including his question regarding his citizenship. A person who was recommended by the Constitutional Council for the position of Chief Justice was not approved or was denied by the Parliamentary Hearing Committee. And the latest fiasco, of Tolerance of Rana, where, there are 30 or 60 days when the court didn't function well. And there was a strong impeachment motion that filed against him, and he had to really defend his stance, although the parliament has not really given his final verdict on that. So that way, this kind of a situation has never occurred in Nepal's judiciary before that. So judiciary is also going through a very difficult phase, I would say. I think, and some sense of stability has come back. And also, even latest, Harikrishna Karki, he had to be acting Chief Justice for almost 90% of his tenure. So you can imagine, judiciary is not in a robust shape that it is supposed to be. But in the executive side, although the Prime Minister has been changing, there is some sense of democratic stability there. Here in the judicial side, if the Chief Justice is not stable, the entire judiciary is not stable. And that is the repercussion that we are facing right now. And I'm going to the question now, judicial independence now. Let's talk about that a bit. What we need to see is in countries' governance, now it's not only the executive, but even the judiciary has become an integral part of country's governance. Because so many issues come to the court from, project development to environmental issues, to whether a person could be given amnesty or, all that kind of, all sort of issues. So there is some role that judiciary is also playing in the country's governance now. And in that case, I think, emphasizing too much on judicial independence and not talking about judicial accountability in same power will not be good. Judicial independence and judicial accountability now should be treated in same power. And that is what the treatment in terms of that two in institutional arrangement is not equal.
I'll just stop you here for a moment, Semanta. It's a very interesting idea that you brought about on judicial accountability. If you were to think it from the executive side, the accountability in political parties would be that it's to the voters, right? What is the reference when you're talking about judicial accountability?
Ultimate accountability for judges is that if they don't perform well, then there is the impeachment process that could be presented and they could be removed. It's not very easy to remove them because you need a voting strength in the parliament to remove them. But that is a very extreme accountability. We should figure out some way to make judges accountable somewhere in between. And that is where I'm trying to talk a bit more about. For judicial independence, there are robust arrangement, institutions, provisions in the law that are in place. The Constitution of Nepal, if you compare to any other constitution, gives enough independence to the judiciary in terms of institutional arrangement. There could be argument, no, this is not enough, but when you compare, it is still robust enough. But whether there are adequate provisions in the law to make judges accountable or not. I mean, when I said equal footing of both judicial independence and judicial accountability. For accountability, there is not enough provisions in the law, definitely. That provisions are lacking in many ways. There is one code of conduct for judges, but that only talks about code of conduct. It doesn't say, okay, these are the standards which judges should abide by, and these are the standards based on which the performance of the court, performance of the judge will be audited. That is not there in the law. And without that, we can't really give so much of independence to the judges and not make them accountable. So we should now try to also have provision in the law which says, okay, these are the standards against which the performance of the judge will be measured, and there will be some biannual kind of a performance audit of the judges. And that way we could really start having some accountability that we could expect from the judge. The reason is judicial independence is not only independence from the executive, and judicial independence, the reason that is needed is to make sure that judges function well, not just being, away from the executive. And I'll try to just summarize my thoughts here. For me, it is now required that the institution which are meant to oversee the judiciary, including the Judicial Council, is given more expanding role, not just to appoint judges, but also to measure the performance of the judges against certain standards.
That's an excellent point, and I'll come back to it when we're talking reforms in the judiciary. But something that I wanted to follow up with on that thought is, in your article in the Kathmandu Post, you quote, on more occasions than not, the political actors themselves are more than willing to cede authority to the judiciary. Why do you think this is the case? Is it emanating from the inability of political parties in Nepal to draw political consensus on constitutional matters and hence favor the role of judiciary? Or is it mostly driven by the fact that political actors have significant leverage in the court, and because they can't draw consensus, they feel that it is easier to kind of negotiate agreement and support decisions for their own interest and then go to the judiciary? We've seen this trend recently in the recent Supreme Court cases on government formation and all. So why do you think this exists?
I would not return that statement. If Nepal have had a strong executive in the last 15-20 years, Nepal never had that. There's always been a coalition government. And still Nepal was going through a very transition kind of phase of passing a new constitution. I really wonder if there is really strong government in place, whether the judiciary can really withstand some of the decisions or the measures taken by the executive or not. That phase we have not got to witness yet. And that is where the power of the judiciary will be really tested. Now the executive is also slightly weak. Mm-hmm. And that is the reason it's very fragile. You never know when the government's going to change. So that's the reason the judiciary is trying to have that more clout, really intervene in the decisions. On a question, it is both, is why I'm saying that the political actors really want to cede the authority to the judiciary on certain matters. Is both. One is certain that because the appointment of judges is not free from political influence and alignment, Some judges, the politician will align with their ideology. I'll not say with their party. In many ways, that's even the case with the US Supreme Court, because you can always call that person is a Trump judge, or that is a Biden judge, or Obama judge in US Supreme Court. And that's the reason how, the abortion case got changed very recently, because the Republican and Democratic judges' background and the number of judges representing both these ideologies, numbers got changed in the court. I will not say same, but similar is the case in Nepal also, that because there is some political backing, a political reason based on which the judges are appointed, the certain political parties will be considered more comfortable that these issues are handled by the justice. Second is also because the politician, when they arrive at a consensus and they don't want to be held accountable, responsible, or to be use a word, blamed for the decision they take. So they will say, okay, we arrive at a conclusion. Now someone will definitely challenge this before the court. The court will give its final verdict. So then they don't have to, be made responsible for the decision they take. I'll give you one example. Back then, when the constitution making process was going on, the Constitutional Assembly's term got expired, and it was extended a number of times.
This is the case of Khilraj Jagmi.
Yes.
Okay.
And Khilraj Jagmi got then appointed as and even that question never came. The Supreme Court had never had a chance to really go into detail regarding the constitutionality of appointment of Chief Justice as the Prime Minister of the country. But before that, number of times the Constitutional Assembly's term was extended, and that was done to a political compromise and consensus. Most parties agreed to that. But whenever it was challenged at the court would say, no, that is illegal. Number of times said this is the last extension that you can provide. So somehow you can assume that the political parties were not sure on the consensus they had arrived, but they just took that as based on the political experience, political compensation, they came to the conclusion, but then allowed the court to then intervene and correct the consensus they had arrived.
Now, these are interesting points, Semanta. And you briefly mentioned this in the question before about reforms. So you mentioned expanding the scope for the Judicial Committee. Judicial Council. What other reforms are being discussed on the judiciary side, especially for the reforms in the Supreme Court? And where are these reforms at the moment? I'm also interested to hear, why are reforms so difficult in the judiciary?
Let's start with, is it the time that we need reform or not in the Constitution? Because when you talk about reforming the judiciary, then the Constitution will need some amendment, because all the functions and of the judiciary are kind of elaborate within the provisions of the Constitution. One reason why your question whether reform is getting difficult is whether the parties are really ready to make changes to the Constitution at this stage or not. It is a very young Constitution. And if you try to amend one provision, there could be a need to amend certain other provisions. The Constitution arrived after a long, drawn political process, which was painful. We are all aware of that. So reform in the judiciary will take time because of that. If it is a requirement that the Constitution needs to be amended, because you've been seeing that there is call from different sides that some of the provisions, including even call for federalism, to be revisited. So if one provision gets touched, then there could be a situation that other provisions will need to be also be modified or amended. That's one. Now, without touching the Constitution or without meddling with the Constitution, can we conduct few reforms in the judiciary or not? And that's definitely the case. We can. And there are talks about at least 3 things that needs to be done in the judiciary, especially in the bar, that needs to be amended. One is the composition of the Judicial Council. The composition of the Judicial Council right now is slightly executive heavy compared to judiciary heavy, because there are only 2 judges, and
both of them are from the Supreme Court.
And then the remaining are, one is law minister, one person is an appointee of the prime minister, and one person is a appointee of the bar. And the argument is that, if the appointing body is not judiciary heavy, then that is against the principle of independence of judiciary. So there's one call to really change the composition. One. Second, again, debatable. I don't know if I fall under any side of that, is whether there is a need for the judges to be appointed to the Supreme Court to undergo a parliamentary hearing, which is in many ways perfunctory most of the time. It's just formality sometimes. And sometimes it is not, except for one case who got denied of his judgeship. But there is also a call to remove that requirement of having a hearing for judges' appointment. And third, that's been recent call, is whether the Chief Justice is getting compromised or swayed away by politicians because of him or her being in the Constitutional Council. Constitutional Council is a body that appoints, all these members and chairs to different constitutional bodies, and Chief Justice also is there. The reason why Chief Justice was made to be part of it is to make sure that he checks and balances, both the opposition party and the ruling party from taking any decisions which is unfair or capricious. In recent time, it is now visible that the Chief Justice is also trying to appoint people close to him or appoint his people in the constitutional bodies because he or she is in the Constitutional Council.
It happened with the last
Yeah.
Supreme Court.
So if that is the case, then there will be a bargain that goes on, a negotiation that goes on within the Constitutional Council. And that could compromise the Chief Justice's role in the Constitutional Council, also in the judiciary. So there is also a call to re-examine whether there's a need for the Chief Justice to be in that body or not. So these three are the major ones that are being discussed. Other that I proposed, I won't say I proposed it, and there's a lot of people who've been discussing that. The other one is definitely to have the Judicial Council's role slightly modified and expanded to see if it can measure the judge's performance on certain established criteria. And I don't think that will need a constitutional amendment. That could be done through the Judicial Council Act. And those are the major ones that's been discussed so far.
Semanta, you mentioned this idea of not having parliamentary hearings for appointments. Why do you say that? Why wouldn't you want hearings to be made for?
It's not, I want or not. It's just I presented that it's an idea that has been discussed in the legal fraternity. It's not that I stand on either of the issue, because sometimes having a parliamentary hearing also benefits in many ways, because the judge's outlook for the judiciary and his concept for the judiciary and his plan for the judiciary could be then present to the parliament and then the parliamentary committee, and then the parliamentary committee could take a stance whether it wants to approve the appointment or not. And the reason behind the rationale for having a parliamentary committee have a look at the appointment is that, as you said, how are judges made accountable? Judges can be made accountable. Judges are not elected persons, right? Parliaments are elected, and there's an argument that the parliamentarians represent the people. So as a representative of the people, they could indirectly have a say on the appointment on behalf of the people of the judges. That's how, the parliamentary committee hearing got introduced. But, the parliamentary hearing could have some impact, is the argument that the judicial independence might get compromised, because to make sure the judge gets approved by the parliamentary committee, whoever is appointed, he or she then might want to negotiate certain aspects of his performance so that he gets an approval. And that's the reason why there's an argument or a proposal that the parliamentary committee hearing is not needed.
Yeah, very interesting. I mean, it looks like what the system that we have in place is like a double check system where the Judicial Council nominates and then you go to the parliamentary process and then you get a stamp of that approval. I don't know. I'm as you're speaking, I was trying to wrap around this idea, and then I'm not clear myself because it's very difficult to take away politics from appointment, especially when you have a judicial council that comprises of the executive and the person nominated by the executive and the bar. And personally, I'm not from the judicial fraternity, but the bar itself is highly political in nature. So you have more people in politics deciding who gets nominated. I won't make you answer that question. But moving on, Semanta, something that has really intrigued me is this ability of judiciary to enforce decisions, right? Time and again, they've been really interesting decisions, really groundbreaking decisions, supportive decisions in public interest that the judiciary has taken. But I've observed that these decisions take place and we kind of are sitting around thinking when they will be implemented. So the onus is on the executive. So this idea of judiciary being able to enforce decisions through the executive, is that a correct reading that the Nepali judiciary in that sense has less of an ability to enforce decisions? I'm thinking about cases such as you mentioned also allowing voting for overseas Nepali residents. That's been decided by the Supreme Court and then it's not been provisioned as of now. What do you think about this ability of judiciary to enforce decisions, and why does the judiciary struggle to follow up on timely enforcement?
Once the decisions come out from the court, the execution of the judgment then falls under the prerogative of the executive. Judiciary does not really have the strength or even the power to really get the judgment executed. In some cases, Supreme Court has, for policy reasons and reasons where to meet the aspiration of the people, have taken certain decisions which have required the executive to implement the decision. And number of cases have been in those lines, including the current decisions on allowing gay marriages, whether there is a law in place or not, and even whether Nepali people who are residing outside Nepal can vote or not. Judiciary's idea of giving that decision is to drive policy reform or drive or help the executive to take certain policy reforms. Take an example of allowing voters outside Nepal to vote. The infrastructure for that, the judiciary can't put in place. That is infrastructure that only the executive can put in place. Whether executive has the strength or not, or resources or not, to put that in place is a question now, because election also means fair elections. And whether allowing people to vote outside of Nepal can result in a fair outcome or not. So, it is more of judiciary trying to suggest in some of these things that executive you need to do, and the executive then needs to try to implement that, but then there are resource constraints that really sometimes makes it very difficult for the executive to implement those decisions.
Semanta, this has been a great conversation, and before we end, I want to talk about something really tangential to today's topic, Nepal's international agreements. You've been part of many of these agreements. Nepal has entered into agreements with MCC, there's a MOU on BRI. These are some recent agreements, but these are not the only agreements. There have been other agreements that Nepal has been part of. These agreements, especially the bilateral ones, have been heavily criticized and remain controversial in Nepal. As a practicing lawyer, do you think such politicization of Nepal's international agreements tarnish its reputation, especially when Nepal is now looking to mobilize more public and private foreign investments? What is the global outlook on Nepal's current performance and practice in international agreements and honoring these agreements? How much impact does such politicization have on Nepal's future prospects to draw investments from outside?
I think interesting question and very difficult to answer at the same time. I'll start by saying that I've been very fortunate to be involved in some of these very important bilateral agreements that Nepal has signed with large foreign corporations and with other countries. These bilateral agreements, are only legal sometimes. They also carry some political and diplomatic features. And if they carry certain political and diplomatic features, avoiding the agreement to enter into political sphere will be very challenging. You can't really avoid that. A series of agreements, starting from Sugauli Treaty to current, BRI or MCC, there's been the same case. In between Sugauli and MCC, I think, or BRI, we had the bilateral investment treaty with India, which got controversial when Prabhuram Bhattrai went to India and signed that treaty. PIPA. Again, that got very charged with controversies. There are other cases, especially water resources agreement from Mahakali Treaty to Koshi to Gandak, all agreements have had their own share of political controversies. There are multiple reasons why this happens. One is some of the time the negotiation that undergoes behind the agreement is not very transparent, and the government just signs it. Then the political parties or the populace will think that no, that's not very transparent. I was not aware of it, what was negotiated. And the government did a good job in making sure the interest of Nepal was protected. So that's why it gets a little charged up. Sometimes it happens that some of these agreements are really complicated and complex in nature with hardcore legal jargons, which a general populace will have difficulties in understanding. And then those clauses will be misinterpreted to make some political gains. And that's why it gets controversial. To answer your question, whether Nepal has respected the international agreements that it has signed or not, I would say the performance of Nepal has been acceptable so far, especially when disputes have been filed against Nepal. Nepal has tried to defend those and abide with the provisions of the agreement in doing that. Even the recent NCL case, initially Nepal did not want to go to the ICSID when Axiata filed the case against Nepal under the bilateral investment treaty between UK and Nepal. But ultimately, Nepal decided to go and defended itself well and won the case also in many ways, saying that the claims that NCL and Exihata were taken was not the breach of the bilateral investment treaty between UK and Nepal. And there are other multiple cases that Nepal has faced in other jurisdictions. These are not bilateral, those are more contractual disputes, more contractual in the sense more of construction disputes. And Nepal has defended that very well. We could definitely do better in many ways when before or signing of any international agreement that is needed, because international agreement have, especially if it's a treaty, has the implication of modifying your domestic law. And when there is a domestic law that gets passed in the parliament, there is a huge debate that usually happens. But if you sign an international agreement, the debate that happens before is not happening. It only happens after the agreement gets signed. So the government needs to be more transparent whenever it's negotiating a bilateral agreement, and try to take any other laws that the parliament passes. The government should try to take more of the stakeholders' views and feedback before signing bilateral agreements. With regard to mobilization or investment, more than the bilateral agreement, there are other factors that really come into play in attracting investment now in Nepal. It is to do with other factors, whether Nepal has competitive edge in certain area or not, and all those factors come into play in attracting investment. I would certainly say that Nepal is more than willing to sign financeable, kind of a bankable agreements with international investors so that their investment in Nepal is protected. So there is a more of a conducive legal framework that is in place, bilateral legal framework in place for the investors to come invest in Nepal, but only that is not enough. There are other things that are required, and this is where Nepal probably needs to improve and do better.
Excellent. Just before we end the conversation, Semanta, something that I've been holding off, and this may be a curveball for you. So in the recent past, there's been strong criticism against federalism. I won't say that we should stand against or for federalism, but something I'm thinking out loud here. Imagine there might be a case in the Supreme Court. I don't know if there is, but somebody registering a case in the Supreme Court saying that we don't need federalism or we don't need provinces. How might the Supreme Court act on this, whether this is a legal or a political question?
It'll be pretty easy for the court to decide on this, because the court can't amend the constitution. The court can only interpret the constitution. And saying that federalism is not required will be amending the constitution. So it'll be very much the prerogative of the parliament here, and courts, I would assume, will not intervene, because that will tantamount to amending the constitution.
Just before we end, Semanta, is there anything you want to add from your side?
From my side, for today's conversation, I got to relook into some of my legal understanding. I really questioned some of my legal understanding also at the same time. And I would suggest that PEI also looks into other judicial reforms aspect, because judicial reform has impact on policy reform. And certain tasks that I can undertake is my suggestion to PEI. And to the listeners, thanks for the patience, and hopefully I'll get some feedback.
Thank you, Semanta. Thank you for coming in today and making time to do this podcast.
I really enjoyed thoroughly. Thank you very much.
Thanks for listening to Pods by PEI. I hope you enjoyed Somitra's conversation with Semanta on the political question doctrine in Nepal's judiciary. Today's episode was produced by Nirjan Rai with support from Kushi Hang, Ridesh Sapkota, and me, Sonia Jimmy. The episode was recorded at PEI Studio and was edited by Ridesh Sapkota. Our theme music is courtesy of Rohit Shakya from Jindabad. If you liked today's episode, please subscribe to our podcast. Also, please do us a favor by sharing us on social media and leave a review on Spotify, Apple Podcasts, Google Podcasts, or wherever you listen to the show. For PEI's video-related content, please search for Policy Entrepreneurs on YouTube. To catch the latest from us on Nepal's policy and politics, please follow us on Twitter at tweet2PEI. That's tweet followed by the number 2 and PEI, and on Facebook at Policy Entrepreneurs Inc. You can also visit pei.center to learn more about us. Thanks once again from me, Sonia. We'll see you soon in our next episode.